Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to our Curious Amalgam, the official podcast of the American Bar Association's section of Antitrust Law. I'm Matt Reynolds. Today's episode is What is the Role of Behavioural Economics in Consumer Protection Enforcement, the UK's new DMCC Act regime. The Digital Markets Competition and Consumers Act 2024 introduced significant changes to the UK consumer protection regime, including new enforcement powers for the Competition and Markets Authority. The CMA is going to need robust evidence to support these new powers, including granular consumer behavior analysis. Today, we're talking about the role that behavioral economics will play in this new regime and how behavioral economics may play a role in consumer protection law enforcement in other jurisdictions around the world. My co-host for today's conversation is Matthew Hall. Hello, Matthew.
Hi, Matt.
Let's go ahead and introduce our listeners to our featured guest today.
Thank you. Our guest today is Stefan Hunt. Stefan was formerly the Chief Data and Technology Insights Officer at the UK CMA. While in that role, he was our guest on episode 86 when we discussed the use of advanced data analytics by antitrust and consumer regulators. He's now a partner at Keystone Strategy in London, leading its technology services in Europe and behavioral insights globally. Amongst other work in that role, he has testified as a behavioral economist in the first UK competition law class action to go to trial, Le Paterel v. BT. Hello, Stefan, and welcome to the show.
Thank you very much, Matt and Matthew. Great to be back here again.
Indeed, you're a friend of the show, so thanks very much for coming back on. So as Matt mentioned, on 6 April 2025, significant changes to the UK consumer protection regime were introduced as relevant provisions of the DMCC Act 2024 came into force. The UK CMA now has the power directly to enforce the law in the UK and sanction breaches. This will result in infringement decisions by the CMA and potential fines of up to 10% of worldwide turnover. Listeners familiar with our podcasts will recognize similar powers to those that the CMA has had for a while under its competition law enforcement regime. The powers will apply to existing consumer rules brought together in the DMCC Act, including 31 existing unfair commercial practices. But the Act also introduces rules covering other areas, including fake or misleading consumer reviews, so-called drip pricing, and subscription contracts. These changes are widely expected to result in more consumer cases in the UK, and the CMA has said that it has been preparing its first cases for some time. So, Stefan, we're going to talk about behavioral economics in this area. Could you please briefly help us with what we should be understanding by behavioral economics in this context?
Sure, absolutely. So I think the best way to understand behavioral economics is literally just the intersection of psychology and economics. So behavioral economics is this well-established field that combines the insights from these two disciplines to understand and explain how people really make decisions. So importantly, I think for a competition audience, an antitrust audience, it's to understand that it differs from neoclassical kind of microeconomics, which assumes consumers make perfectly rational decisions. But in contrast, it considers real-life factors like competing demands for people's attention, limits on cognitive capacity, and inbuilt biases such as inertia. So that's how we should think about behavioral economics.
Okay, recognizing that we're not really rational agents, either at all or often, as I understand it.
Yes, I think we can all speak for ourselves when we, with some introspection, when we realise that, in the words of an excellent recent research paper, we're all behavioural more or less. When people are listening to us right now in their cars or maybe with headphones on, just for example, they'll be processing loads and loads of language information. So literally what's happening there is like there's vibrations going through the air The hairs in the ear are picking that up. There's going to be the most basic levels of kind of auditory perception. There'll be all this higher level language perception. And that's before we even get to the conceptual stuff, and of which we're almost completely unaware until we start talking about it right now. So I think it's broadly recognized that the vast amount of processing that goes on in people's brains, and of course this is the nature of evolution and human brains, the vast majority of processing it's not strictly rational or cognitive as such. It's these kind of more simpler kind of associative processes. And that's great. It means that our brains are really well adapted to do many things well, but it means that we can also have issues at times as well.
Indeed. I didn't think we were going to get into the science and biology, but that's good. We can move on a bit back to consumer protection. Stefan, I know you've been thinking about the evidence analysis that's going to be needed in particular here in the UK for these consumer protection cases. I know the CMA has been using this for some time, of course, but what do you think is the broader context that we should be thinking about as we start to discuss this subject?
Yeah, great. Thank you. Well, I think there's three main things to think about here. The first one is we'll have a quick kind of sojourn into the nature of the law. So there's, in particular, in the consumer protection law, which is mostly based on European law, first of all, we have to identify a breach, which could be a misleading action, could be a misleading omission. There's some other breaches as well. And then within that, have to think about, at least for the majority of cases, causation. Here, in particular, there's the idea that the average consumer is defined in a variety of ways, will have changed one of their transactional decisions, which a transactional decision can be a whole variety. It's quite a broad concept, a whole variety of things to do with purchasing a product or a service. So you have to think, so first is we've got the breach and we've got causation. So we're going to have to think about what evidence is going to bring to bear to understand whether there's a breach or whether there's been causation. So that's the first thing to say. So the second thing to say is, well, let's just think about how evidence and analysis has been used historically in consumer cases, primarily focusing on the UK. And the first thing to add to that is that actually there's been very few major cases that have been litigated that have reached the courts. So we've only got a little bit of information. And this in part reflects the fact that until these major changes, where now the CMA has all these administrative powers, consumer protection had a much, much less focus than competition law. And we can see from some of the cases that have gone to court that actually the judges have been quite skeptical about some of the evidence that the CMA has tried to bring to bear in the court cases. One particular case on sort of care homes, we actually found that there were 4 particular consumers that the CMA had taken forward to give evidence to the average consumer. Well, that was rejected by the court. There was some covert analysis that the CMA had done that was also rejected by the court. If we look at trademark cases where there's also this focus on whether something has been misleading or not, there's been real skepticism about surveys. So, for example, there's some listeners will know about the Whitford guidelines that are needed for surveys. So there's quite a lot of focus on judges making decisions themselves. So one might think that actually there was potentially quite a lot of resistance. In particular, it's the High Court that matters here, to the use of kind of expert or broader evidence. So that's all just to set up to say is I do not think that's going to be the case going forward. And let's talk a little bit about why. So my third point there is I think we need to think about a much broader context in terms of evidence that's been used in court cases in the UK and more broadly, and actually even beyond court cases. So I think the broader context is there's been a massive revolution in how we understand consumer thinking. And in particular, I'm sure you'll be aware of the book Nudge by Cass Sunstein and Richard Thaler. So Cass is the number one most cited academic lawyer globally, and Richard Thaler has a Nobel Prize now in economics. And that's really 2008 book really popularized the idea of the use of behavioral economics and behavioral science more broadly in policy making. And this is and that's just one example of this huge focus and development on our knowledge and understanding in this space. And that perhaps unsurprisingly, has been reflected in court cases and cases outside courts as well. And this has been growing, increasing use of behavioural economics and actually other non-traditional economic expertise as well. It's actually technology expertise as well. And we're seeing this reflected in competition and consumer cases within the UK and globally. So starting with the US, so for example, we're seeing considerable use of behavioural economics in a number of major antitrust cases. So in particular, the US v Google search case that was in court last year and is currently in court with respect to remedies, the FTC versus Facebook, Google Play Store litigation and more. We've seen the real use of behavioural economic evidence. So just focusing on US v Google search, Antonio Rangel, who's the expert for the DOJ, used a whole variety of very interesting evidence. So I'd really commend to the audience to look at his evidence if you can. Looking at Google's own experiments and defaults, internal documents and discussions of defaults, in particular search. And Google's own behavioural economics team was this great font of evidence for him as well. Google's analysis of other firms' defaults, in particular focused on Apple's podcasts, Apple's Maps, Microsoft, Amazon. And then he also did a whole lot of customer journey analysis, looking at what consumers would need to do to change their defaults. So this is an example of how behavioral economics has been used in a case. And the judge responded incredibly well to that evidence. In like 25 pages of the roughly 250-page judgment was the judge referred to this kind of evidence. And we're seeing it reflecting a whole bunch of consumer cases as well, such as the FTC's case against Amazon focusing on Prime. We've seen this in the UK too. So, for example, I testified as a behavioural economist in the Behavioural v BT case, and I'm working as expert in a number of other class actions. And the court actually were very amenable to behavioural economic ideas. And we're seeing this across many more cases as well, including, as I said, these wider expertises, including technology.
Great background, Stefan. Bringing it back to the UK consumer rules in the DMCC Act, you mentioned at the beginning there the question of there being a breach and causation, and you referred to a phrase, changing a transaction decision, which I think is pretty important here in the UK rules. So I think you're referring there are certain prohibited unfair commercial practices under the law, which are only unfair if they're likely to cause the average consumer to take a transactional decision, as you mentioned, they would not otherwise have taken. And I think the phrase often used by the CMA and in the guidance and in speeches is they would have caused it to take a different decision, which seems to be one of the key areas where behavioral economics is really going to bite here in practice, in applying the law in the UK. So do you have any comments you would like to make in relation to that particular issue of analyzing a different decision? I mean, maybe customer journey analysis that you mentioned there at the end is one kind of area here.
Yeah. So obvious disclaimer that I'm not a lawyer, but I can point out some of the relevant parts of the law. So you've discussed the transactional decision-making test, which is likely to cause the average consumer to take a transactional decision they would not otherwise taken. So inherently within that, we need some kind of, you can think of it as a theory of consumer decision-making. I mean, some evidence in some kind of alternative way that the firm would have acted, that people would have taken a different decision. So there's a variety of ways that we might get at that. One is really understanding the factors that affect consumer decision-making. Now, as I was alluding to, there's very large literatures focused on this. We also might get specific evidence related to the case. It may be, for example, that firms have tried experiments. I mentioned some of Google's experiments on defaults, for example. There might be some really good evidence that the firms have that might be brought to bear. It's even possible, in fact, that the authority might want to create their own evidence as well, either through experiments or through surveys or these kind of things. So there's a whole variety of evidence that could be brought to bear. But we also talked about what the breaches of the law might be. So this idea that it could be a misleading action or a misleading omission. But we have to also think about in that context, what might constitute something to be misleading. It's not necessarily a prima facie obvious what that might be. We need to put evidence on that. There's a whole variety of other language actually within the law that we're bringing specific sort of evidence may be important. So the law talks about You mentioned subscriptions, Matthew, and people have to basically exit subscriptions easily, straightforwardly, with no unnecessary steps. Well, that's how do we judge that? Or disclosure needs to be prominent. Again, how do we judge that? So it's been pointed out by the CMA's former head of the Markets and Consumers Executive Directive that behavioral economics and digital skills will be key in these areas. And I think that's right.
So yeah, so it's a range of points. I mean, as you say, there are a range of phrases in the law where this is going to be relevant. What is a misleading practice leading to an unfair commercial practice in some cases? What do we mean by prominence? And as I understand it, you're saying, well, look, we're going to look at a range of issues here. Historical data, surveys, experiments, even academic literature, I guess, and presumably, as ever, as you mentioned in the US Google cases, internal documents are going to be something which you are going to be poring over before the regulator looks at as well.
Yeah, I think, I mean, obviously it's going to vary quite a bit according to the case and the evidence that might be brought to bear. But yeah, I agree with all those things. So I think that we're going to get direct information on consumers could be helpful. So I mentioned the Whitford guidelines earlier about surveys, but actually, for those of us who've been working on surveys for many years, those are all very reasonable guidelines for making sure we have rigorous surveys. So absolutely, I think the behavioural literature can be useful, but I'd point to the Paterel v BT judgment, where the Competition Appeal Tribunal in the UK was amenable to these behavioural ideas, but it really wanted to see, where possible, situation-specific evidence. And when particular biases, such as, say, cognitive dissonance, or these things were mooted as being possible influences, but without specific evidence, that they really considered that was speculative and dismissed it. So I think the literature will be helpful, but it needs to be done carefully. Internal docs, yes, I think there'll be a font. I think experiments will be a font as well. But also, I think quite often quite granular data on people's decision making. What did they see when they were making a decision, and how did they make decisions? I think could be very useful. And last, and by no means least, I think, is the increasingly, I suspect we're going to see cases about algorithms. And we've already seen quite a number in the consumer space. And within those cases, I think we will be getting into source code and documentation. We've already, the ACCC in Australia have a case versus Trivago that went to court 3 or 4 years ago. And the source code and documentation was very important there. So those are the array of different types of evidence, I think, that will be brought to bear in these cases.
On that last one, Stefan, how does source code, i.e. the kind of underlying software program, how does that relate to the behavioral economics analysis? Or is it saying, well, look, you have to look at the design of the program and what it was actually intended to do right from the bottom? Is that what you mean, or is it something else?
So it's going to vary by the case. So in the ACCC Trivago case, the source code was an important piece of evidence because it showed that the ranking that consumers were given was influenced in particular by the commissions that Trivago was receiving. And that then contrasted with the information that had been provided to consumers by Trivago. But it may be the case that we have to think about other elements of the choice architecture that's being given to individuals. And you'd really want to understand, what is determining that choice architecture. And that's where I think getting into the source code and sort of computer science or data science elements will be very important. Then I think you need, allied with that, you then need to understand the impact of that on consumers. So those how the sort of, the data science, computer science and the behavioral science would need to work together to address cases like that.
Okay, that's very helpful. That's an interesting way of setting it out. So, Stefan, moving on, you mentioned there OCA, online choice architecture. I know the CMA has done a lot of work in this area, and I think we can call it kind of cross-cutting in that they've done work on OCA as it applies to a whole range of particular cases. So maybe you could talk us through a bit what the CMA, and I know you did some of this when you were there, but what the CMA has done generally in relation to online choice architecture, and then maybe we could look at some specific cases in the consumer protection area where behavioral elements were particularly relevant?
Sure, absolutely. Yeah, so I initiated the CMA's online choice architecture work back in 2020. So I'd been actually thinking about it since just before I joined the CMA. Was mostly at the time actually influenced by competition cases, where I thought there were examples of dominant firms who had been choosing choice architecture that was effectively self-preferencing. But also we developed this into a whole line of work, and the CMA published a couple of papers in 2022, really trying to detail the latest that was known about online choice architecture. And that influenced a whole number of the CMA's cases. So first of all, in competition, there was the digital advertising market study, the mobile ecosystems market study, where choice architecture was part of those cases. But it was also influencing, as you've alluded to, Matthew, the consumer protection work. And what we saw, that there's a whole series of cases that have come in the last few years. There's a case against Voucher, another one against Simba Sleep, another one against Emma, which is another mattress firm, looking at different elements of these, of choice architecture, and how this had influenced consumers, as we know, to make a transactional decision they would not otherwise have made. And the CMA's signalled, well, I know that the online choice architecture work is still ongoing, and it signalled in its draft annual report a few months ago that in the consumer protection space, it will still be looking at these online choice architecture effects. And the original piece of work was set up to be a piece of work that would be influential over a 5-10 year horizon. So I would expect us to see quite a number of these cases going forward.
And you mentioned there the Simba Sleep and Emma Group. So these are investigations into basically online selling by mattress companies, so retail sale of mattresses by Emma Group and Simba Sleep. And investigations looked in particular at urgency claims, I guess the ticking clock or what have you on the website, and price reduction claims by these mattress companies. It might be helpful to understand, the particular factors in relation. So I guess applying what we've been discussing here to how you might analyze the real impact of an urgency claim or a price reduction claim to someone sitting there in front of his or her screen and potentially being negatively influenced by that.
Yeah. So I should say that I was involved in the sort of the very early stages of those cases, though I wasn't involved in the details, and that was been some years ago since I've been involved. So without being involved in the details, I feel like I can talk freely. I think obviously with these kind of cases, like first and foremost, we just have to establish the facts. So in this case, it would be what statements were provided to individuals and how factually robust were they. And when it comes to urgency claims and indeed countdown timers, then you have to think about what's the relevance to individuals in that specific situation. I don't know the details of these specific cases again, so I can speak freely. My understanding more broadly is in that some of these cases, there's been sort of countdown timers which have just effectively totally arbitrary, and then they will reset when the time has gone down. So obviously that seems like it might be, or is potentially problematic. It seems to have a misleading element to it. And when there's kind of urgency or popularity claims, we'd need to examine those. And the CMA actually in this online hotel booking some years ago looked at kind of scarcity and popularity claims, whether they're correct or not. But that's just really thinking about the breach. We then need to think about the causation. And we need to try and understand, are these likely to really have an impact on transactional decision making? And there's a variety of things one could do in that space, right along the lines of the different types of evidence we were talking about previously. I think probably the most influential would be looking at variations in how information was presented to consumers. And I think you can show potentially quite directly the impact that would have on consumer choice. So that would certainly be my go-to. If that were not available, you'd then want to start thinking about how you might kind of do survey work. Sometimes, and I know we're thinking about this in another interesting CMA case, you could try to think about sort of natural experiments. So often there can be interesting variation in the data historically. And we had a plan on one of the CMA cases a few years back where we were going to collect these really granular data on consumer decisions. And it turned out that there's quite interesting, useful natural experiment, and that was the planned analysis. Now everything settled, so we never got there. But I think broadly those are the kind of things that you might want to be thinking about.
That leads me to ask, have there been past cases where there's been an attempt to recreate the circumstances of the choice that was made for the fact finder or the judge or judges at issue, basically to put them in front of a computer, if we're talking about an online transaction, and replicate or reproduce what the average consumer is seeing on the screen and what happens when certain decisions are made? I was curious what role that plays versus presenting after the fact evidence based on others having done that or having compiled data points on that experience.
Yeah, interesting. So in the UK, in consumer law, there's not been any evidence, to my understanding, to date like that. And if we're considering competition cases, I don't think there's been anything thus far. But I think it'll be coming very soon with this large array of class actions. That said, we absolutely have the potential to use evidence that will be relevant to the court. Actually, one piece of work that I did do was working with a browser company, and we were looking at browser choice screens. And it was an experiment, and you literally could show the different ways that browser choice screens could be configured, and then the impacts on consumer choice. So I think that's quite similar. So you could imagine, and in fact, when I present this work I did in the context of the Digital Markets Act, we have these screens of exactly what would a consumer see. So I think we're going to see a lot more of that kind of analysis in sort of more generally in the UK, and that would include in the consumer protection space.
Yeah, one thing that came to mind for me was the idea sometimes in jury trials, you'll have site visits where the jury will be taken to a location to see what the people involved in whatever the issue is saw firsthand. I suppose that could cut both ways, though. If you have a fact finder or a judge or judges making their own determinations from what they see. Well, if I were sitting at this computer and doing this, I wouldn't have done that. I would have been rational. You wonder if that cuts both ways, and you'd rather stick with the expert evidence that is based on the data gathered rather than leaving it up to what that person sees at that time.
Well, I think you probably want a mix. So actually, I like what you very, very much said about experiencing the consumer journey. In fact, that piece of research I told you about browser choice screens, we were so happy with the way that we'd mocked things up. We actually did a video so you could so that people could see what it looked like in different conditions. But at the same time, I think we have to be very clear that actually intuition cannot be what we expect. So in particular, in that research, I work with I've got a lot of experience in this space. I work with an academic who's really absolutely top of their game in that particular example. And even with all that experience, we didn't perfectly predict what the results would be from this experiment. So I think, but we need to explain that to the judge or judges or possibly jury, and then tell them, well, okay, this is the setup. We have to be quite open-minded. Actually, if you've done an experiment properly, you will have actually pre-registered what you think what the analysis is going to be, and then we walk them through that slowly. And if you do that, my experience has been, if you do that quite carefully, that alone can be very persuasive. In fact, a trick I picked up many years ago from one of the professors in my PhD committee was, whenever you do an experiment, get people to guess in advance what they think the results of the experiment are, because they always get it wrong, and then show the results, and then that makes your results even more powerful in changing people's opinion.
Interesting trick there, Stefan. So looking forward, you've referred already to some of the CMA comments, but this legislation, as we've discussed, has just come into force recently, early in 2025. What kinds of cases are you expecting to see in the consumer protection area from the CMA, given its new powers?
So, well, the CMA has been quite clear to signal that it's really focusing on allowing firms to sort of understand the new law and comply. And that's quite important within the political context in the UK right now. And it makes sense that the CMA is listening to the steer it's receiving from central government. But I think this is going to be an area which is going to be very important. the ultimately consumer protection is something that is quite prominent when it comes to, say, the press or the wider dialogue. MPs' mailbags are often full of consumer protection cases. So I think that we're going to, whilst there's a little bit of a slow start, I think that we've got to think about that in this 12, 18, 24 months. I think there's going to be quite a number of consumer cases. As to what they will be, we look at the draft annual report that the CMA put out earlier this year. I think that's a really good indicator. So it's name-checked online choice architecture type cases, greenwashing cases. It talked about its past cases and revisiting weak cases. And there's a whole variety of areas where it's done things previously where you think they might want to revisit. And in particular, the CMA called out areas where they already have guidance. So, for example, hotel booking will be one. Another area I think is going to be very important from next year is going to be to do with subscriptions. The law doesn't kick in till 2026, but this is an area where there's been a huge degree of feedback from various parties. So I think we've really got to think that's going to be an important area. And then last, and by no means least, I think there will naturally be a tendency, I think, for the CMA to consider using its consumer powers when it comes to medium to large technology firms. As you'll be well aware, through the Digital Markets Competition and Consumers Act, one of the main focuses of that is the new digital regulation rules that come in for the very largest firms. Now, those are very strong powers, but they require a huge amount of resource in order to move those forward. Whereas if we can see if there's specific issues that the CMA might be concerned about, they could put together a much smaller consumer protection team, which could turn around something much faster. And moreover, those digital regulation powers are only for the largest firms, when there's a whole variety of other sort of technology firms that wouldn't reach that bar. So I think for medium to large technology firms, I think we're also going to see a number of cases in the consumer protection space.
Yeah, that's an interesting thought in particular at the end there about using consumer protection rules in that way. And for those who are interested, there's also the CMA's approach document on its use of the consumer powers, and also a recent speech by Emma Cochrane, also a friend of the podcast, who at the CMA on how they're going to take this forward. Finally, here, Stefan, I'd be interested to have for your point of view from the behavioral economics angle on takeaways here. I mean, a couple of thoughts from me are that these issues seem to have a lot of relevance to potential remedies and commitments in these cases, not only in relation to the investigations and decisions. And also, I was kind of struck by a comment, maybe it's obvious, but Emma Cochrane made in her speech. It won't always be necessarily proportionate to undertake extensive, complex analysis on behavioral issues. I mean, of course, the law doesn't always require that, but it was interesting she was flagging that up, I thought.
Yes, no, it was interesting. So I would say Emma gave a speech that we organised with our friends at Linklaters. And it's important also that my successor at the CMA, Karen Croxon, was also at the event and was speaking at the event and talking about the use of kind of data and behavioural skills within these cases. So yeah, it's absolutely right that it won't always be proportionate to use these skills, but I think they're often going to be necessary. In terms of key takeaways, I mean, I'd say this really is a step change. It's putting consumer protection on the same footing as competition law with the same fining powers. Whilst the CMA is starting relatively gently, as we've discussed, I think actually in steady state, we should think that the CMA is going to be using these powers. They're going to be having quite some influence. And so there's going to be a real kind of contextual pressure on the CMA to do consumer cases. So for companies, I think now would be a very sensible time to start preparing. They might want to be thinking about auditing their own activity, think about that in advance. We talked about the areas they might want to pay attention to: online choice architecture, greenwashing, areas where the CMA already has guidelines, subscription traps. I think medium to large technology firms should really be thinking about this in particular as well. So if we can think about firms defending themselves and for their legal advisors, I think personally, they'd want to be thinking about the kind of evidence analysis that could really be brought to bear and that is going to be ultimately persuasive in court. And I think actually the broader context of what's happening in competition and consumer law in the UK and more broadly is the most pertinent thing for thinking about what the most persuasive evidence is going to be. And one element of that is I think we're going to see quite a bit of surveys. I know there's a lot of skepticism in the legal community because of how surveys have been considered in trademark IP cases. But amongst those people who do rigorous surveys, the Whitford guidelines are not really much of a constraint. They're just they're sensible guidelines that I think any good practitioner would want to follow. So that's how I would be thinking about if I was a firm defending themselves or the legal advisors, that's how I'd be thinking about the evidence.
Well, thanks so much for those fascinating insights, Stefan. As you will recall, as a past guest on our podcast, we like to round out our episodes by learning a little bit about our guests on a personal level. So I'm going to ask you a couple of things that are off the topic of behavioral economics, but equally fascinating, I'm sure, to our listeners. If I could ask you, tell us something about yourself that maybe your own colleagues don't know about you.
Sure. So thank you. I was reflecting on this in advance. And so the last time we did this, reflected on a family matter. So it was about the fact I have an identical twin in the space. But so I'm actually going to build on that slightly. And so my mum was a single mum with twins many years ago, and she actually met my dad when we were 3 years old, and he was a photographer that she'd been pulled in to take pictures of her and her kids. And we have all these photos in my family of the first time my parents ever met. But of course, my dad isn't in any of the pictures because he's the photographer. And that's how my parents first got together a long time ago. And my dad's still around, 91, still working. And he's been a real inspiration for my brother and I.
Well, that's a wonderful moment to have captured on film. Well, I think we're going to round things out with the segment that we like to call the Curious Hat.
And now it's time for the Curious Hat.
So, your Curious Hat question for today's episode is, how would you spend your perfect weekend?
Oh, wow. So this can be a bit cheeky, but I have a 1-year-old and a 4-year-old who obviously are the absolute lights of my life. But I think that the perfect weekend would be myself and my partner getting away for a weekend, just the two of us, which has only really happened for one night since our eldest was born 4.5 years ago. So I think getting away to a nice hotel and in a nice setting somewhere, the two of us spending time together, that would just be it.
Well, as a fellow parent, I can certainly echo that sentiment. Well, Stefan, thank you so much for this fascinating conversation today, and thank you, listeners, for listening to this episode of our Curious Amalgam.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.